For those of you who have been at these sessions before, you know we have a very fast-paced presentation for you. We'll be proceeding in order of the outline that you have, starting in order by subject matter. For example, we'll be starting with ADR cases, going through the alphabet of subject matter. We'll be proceeding in order of the outline that you have, starting in order by subject matter. For example, we'll be starting with ADR cases, going through the alphabet of subject for you. We'll be proceeding in order of the outline that you have. For those of you who did not dream of being real property lawyers from the day you were born. First, we begin with ADR, alternate dispute resolution cases. First case we begin with is on page 25, the Guan versus Ellingsworth residential case out of the 5th DCA. Very interesting decision, reminding all of us to read the ADR provisions carefully in the contract in case of a breach before you proceed forward with your remedies. This declaration, which was a covenant running with the land, required that the parties first engage in negotiation, second mediation, and third arbitration. But there was a kicker. This provision also required or provided that if a party failed to go through this three-part process, then that would constitute a waiver, a release, and a discharge of the claim. What happened? Of course, one party did not proceed forward with the tripart requirement for relief. And what the 5th DCA ruled was that even though that Chapter 720, because this was a homeowners association case, permitted post-mediation arbitration, the failure to follow the contractual requirements waived the parties' claims. Moving forward into money issues, assessments, lien, and foreclosures, the first case we'll be looking at, skipping forward, is on page 36 out of the 1st DCA, and that's the Lewis versus Innova Investment Group case. In this situation, the court was dealing with the impact of a bankruptcy upon an owner who is defending a foreclosure action. The owner in the bankruptcy case filed a statement of intention, which in Chapter 7 indicates that the property would be given back to the lender. Based upon that filing in another court, the Florida court held that judicial estoppel barred the owner from contesting the foreclosure judgment because the owner had represented to the bankruptcy court that the owner was going to be turning over the property. Thus, the game was over. Also note on page 44, the BMG Realty Group versus U.S. Bank case came to a similar conclusion. Page 36 was a game changer for the Florida Consumer Collection Practices Act. For those who are not aware, chasing consumer debts in Florida can be problematic, not only because we are aware of the federal Fair Debt Collection Practices Act, which limits many of the actions that a debt collector can undertake, such as you can't call in the middle of the night, you can't threaten an individual with personal harm, you cannot provide a paper that looks like a complaint when it really isn't a complaint. Many attorneys are not aware that there's a similar parallel act in Florida, the Florida Consumer Collection Practices Act. In this situation, the president of an association, and don't ask me why, but it seems like condominium associations constantly get themselves into trouble, but it's good for many of us because it gives us an idea of where the boundaries are for our other non-association clients. Here, the president of the association allegedly violated the Florida Consumer Collection Practices Act, going to an owner and saying, "You owe the association money." First matter that the court held was that a condominium association assessment is a consumer debt under the Florida Act. Since the Florida Act is broader than the federal act, it's likely that it would also encompass under the federal act. Note also the Williams versus Salt Springs case, which is a June 12th case, which was published after the date of the outline, also dealt with the same issue, came to the same conclusion. And also note the Trinchell versus Midland Credit case out of the United States 11th Circuit. That's Trinchell, Tricchell, versus Midland Credit Management. This is a July 9th, 2020 case out of the 11th Circuit again. And this case narrowed the application of the federal act by providing that there must be an Article III U.S. Constitution case in controversy at issue for standing. And if, for example, in the Tridgell case, just sending a letter that did not cause harm to the debtor, that does not give the debtor a cause of action against the credit collector. Next, we have the question of where do you draw that line? The Denton versus HSBC bank case out of the 4th DC on page 38 dealt with a requirement in a mortgage that there be 30 days notice of a default, a somewhat standard provision if you've ever heard of a standard provision. In this case, the bank gave notice, but the bank gave only 24 days notice. For those of you who are real lawyers and you don't have 30 fingers and toes, we'll do the math for you. It's 6 days short. What the court held was that the difference really was not material. It was substantial compliance because the borrower received so much close to what the borrower bargained for that it would be unreasonable to deny the bank of the benefit of providing notice. In this situation, the court also drew a line on the burden of proof, and that is that the owner-borrower, who is the defendant, carries the burden of proof of prejudice that the short notice caused harm. In this situation, there was no proof by the borrower-owner that they couldn't refinance in 24 days, and the court also noted that the loan was in default for 11 months afterwards before the suit was filed. Lost note. Page 39, the Wells Fargo Bank versus Brycourt matter. What do you have to do to prove a lost note? Or alternatively, if you're representing the borrower, what is there that may stop the bank from moving forward? In this situation, the bank's witness testified that they undertook an investigation to find the lost note, and also that there was no record indicating that the note had been transferred or seized. That's critical because if the note had been transferred, then as negotiable paper, someone else may claim a right to enforce it. The 4th DCA stepped back and said, to establish a lost note, the witness only needs to testify that they conducted a search and could not find the note. That is what I would call, and many would call, the magical words proof. Just parrot the words required in the statute for the proof, and then ipso changeo, you've proved up the lost note. Would say as plaintiff's counsel, you need to be very careful as to coaching the witness to testify something that really isn't in the witness's personal knowledge. Moving forward, assuming that there is a judgment in a foreclosure action, is the For People's Choice versus Acanelli case on page 40 out of the 2nd DCA. In this situation, after the lis pendens was recorded, a third-party Jupiter House moved to intervene. And what the court held is that a title owner does not have standing to intervene in a case when they've acquired the property after the recording of a lis pendens. Remember, the lis pendens, you have a certain amount of time in order to intervene, but if you've purchased now, after intervention, all bets are off. Though the court didn't discuss it, I would dare say that this does not address the issue of a foreclosure sale purchaser who needs to intervene to protect the monies that have been deposited in the court. Next, we have the Marketable Record Title Act on page 42. We friendly call that MRTA, because if you don't pay attention to the Marketable Record Title Act, your client may feel as if they've been murdered. In this situation, though, very seriously, there was a claim against a law firm that was alleged to violate against the Florida Collection Practices Act. And the allegation was that the law firm knew that the declaration of covenants upon which assessments were based had been extinguished by the Marketable Record Title Act. And here the court held, the 3rd DCA, that if the declaration is not enforceable because it had expired, then whatever privilege there was, a litigation privilege to proceed with litigation, does not apply because the defendants had no basis to proceed to collect assessments. Let's move into another area, attorney's fees. Dex and Such Marine versus Dake on page 43 out of the first DCA dealt with a contractor's lien dispute. Who is the prevailing party? A little bit unusual from the normal situation. We had the property owner, we had a mortgage holder, and we had the contractor's lien, the mechanic's lien holder. The contractor lien holder sued both the mortgage holder and the property owner in order to obtain clear title, and this was a subordinate lien holder. The subordinate lien holder was able to prove that their lien was not subordinate but actually had higher priority and obtained a summary judgment. That lien holder then moved for attorney's fees as the prevailing party pursuant to the contractor's lien laws prevailing party attorney fee provision. That provides that the, quote, the prevailing party is entitled to a reasonable fee. The first DCA took that language exactly, including the article. For those of you who remember third grade grammar, the article here is the, T-H-E. And the court held that you have to read the prevailing party means one prevailing party, the one that prevails in the action, and then look back at the intent of the statute, which was to assist the lien holder versus the owner. And this was not an issue really for lien holders. And the court held that providing attorney's fees to a junior lien holder would upset the statute's balance. The question is, if you have a contract that provides for the prevailing party, would they also provide such a strict reading in that circumstance? Right of redemption, moving forward, is the Earl W. Johnson roofing case versus Hernandez out of the 4th DCA on page 44. An unusual situation that the foreclosure judgment, while awarding the principal amount, reserved jurisdiction for the amount of attorney's fees to be awarded. But the foreclosure judgment also moved forward with the foreclosure sale even before attorney's fees were awarded. In this situation, the owner, I don't know if this was intentional or not, but paid the amount of the judgment to redeem the property, which was only the final judgment principal amount, but did not pay any part of the demand for attorney's fees. And the 4th held that the owner could proceed to redeem the property on the basis of the judgment amount without paying attorney's fees. This is a word of warning to proceeding forward in a piecemeal fashion. You may want to obtain a judgment for the principal amount before proceeding with attorney's fees, but beware of moving forward to seek a sale before you have liquidated all money amounts due. Civil procedure, the cartoon shows the armies moving forward to the castle. An arrow comes out and the knight says, "Beautiful, that's all we need to sue them into oblivion." A number of civil procedure cases moving forward. Basically, these come mostly out of the foreclosure process. And this year, there is a number of service cases that will be of interest to the practitioner generally. The Magnolia Court versus Moon case on page 77, skipping forward a bit, out of the 3rd DCA, was a situation where there was a foreign limited liability company. That company was not able to be served by the plaintiff. The plaintiff realized that that LLC was not registered to do business in Florida. By not registering to do business, that foreign LLC then came under the LLC Act, providing for the Secretary of State is entitled to receive service of process, and that is the equivalent of personal service. Beware, attorneys, for your clients that are foreign LLCs or other entities that have not registered to do business in Florida properly. Another service of process issue is the Katz case on page 85 out of the 3rd DCA. There, they were trying to serve an individual in Venezuela. The defendant was not at the location. There was a, quote, roommate at the location, and the roommate said, "Yeah, maybe a roommate, but my roommate actually lives in Colombia. That is her place of abode." And those were magical words for the third DCA because that links into Chapter 48, which provides that service is to be at the usual place of abode if it's substitute on an adult living there. And the court held that unlike perhaps a residency, you can only have one place of abode, which is that the place where they are living, not at the time of complaint filing, not at the time of judgment, but at the time at which service is made. Moving forward into the house of straw that is so many construction matters, we're moving into construction land. And the first case we'll refer to as Surety's Choice, to take a name from the movies perhaps. The Sea-Watch case, skipping forward on page 90, is out of the third DCA. In this situation, Sea-Watch discovered that the contractor's work had defects, and as a result, Sea-Watch terminated the contractor from the job. Sea-Watch then made a claim on the surety, and the surety contract provided that the surety may elect to undertake to perform and complete the contract itself, through its agents, or through independent contractors. So the surety had three choices according to the contract. The surety hired the same contractor to do the work. You can only imagine what Sea-Watch's response to that was. Well, in court, they tried to stop it because presumably they'd been through this one before and didn't want to have a reprise. The third DCA, in a trend that I think you're probably seeing through the cases that we've presented to this point and in the future, looked at the language of the contract and construed it. It was clear, and there were no restrictions on who the surety could use to complete the project. Two lessons for the practitioner here is, one, look at the contract, presumably before your client signs it. Second, if you're involved in construction work and you have a surety situation, I don't know what type of negotiating power you have, but you may want to take a look at the actual contract that the surety is going to be issuing, not the one-page bond that they send out with the facsimile signature. Next, we move into NIMBY land, or not in our backyard, as the woodpecker next to the robin reads. So we have a case out of the third DCA, Miami-Dade versus Publix on page 90. Publix sought a variance to allow a liquor store to be closer to its main grocery store. And the question was whether or not Publix was entitled to a variance. As you may imagine, there were some objections, especially from a liquor store in the neighborhood. And the question was, on a second-level certiorari review at the third DCA, was what is the burden of proof that a local government must follow if they are not going to grant the variance? And they held that once the applicant meets the initial burden that the statutory criteria are met, then the variance is to be granted unless the opponent, this would be the other liquor store owner, produces competent, substantial evidence that it would be adverse to the public interest. In this situation, the court adopted in large part the dissenting opinion of Judge Moore, one of our reptile stalwarts, and where she noted that the court could not just concentrate on what the opponents were saying, but first look at whether the applicant met the criteria, and then the burden shifts. Moving forward into contract land, again, we are coming back to the theme of the year, and that is, it says what it means. The Corporate Creations versus Marriott case on page 93 dealt with specific language concerning termination of a contract. You may want to read along on the screen. The termination provision provided that it could be terminated with or without cause and without liability by providing written notice of termination to the other party at least 90 days prior to the renewal date. So, we get to year 5 of 7. The termination is triggered at that point, giving 90 days notice. The fourth held that the language was clear and unambiguous. No extrinsic testimony would be provided or would be accepted unless reasonable minds would differ as to the meaning of the contract. And here there was no provision saying that the termination clause would kick in only in the last year or only in the last 6 months, but the termination provision without having any date could be triggered at any point. At what point can you raise unclean hands or lack of equity in a contract case? Again, on page 93 is the Collections versus Patel case out of the 5th DCA. Very interesting circumstances here, and depending who you may represent between different partners, and remember, if you're representing an entity that's going into development or any type of business, you need to be very careful as to how you approach representation and who is your client. I would urge you to review the Reptile CLE tapes that we undertook about 2 months ago, and Mike Dribbin made an excellent presentation on what happens when you represent entities and partnerships. But in this situation, you had two partners. One partner purchased a judgment against the corporation, and then that one partner proceeded to execute against the ex-partner. Rule of Civil Procedure 1.540 allows relief from judgment when it is no longer equitable to present it. And in this case, the 5th DCA seemingly has expanded the role of equity in contract cases by holding that misconduct is not necessarily required to evoke equitable powers. Because in this situation, the partner purchasing the judgment did everything apparently according to the book, even though it may stink. And here the court held that it would not be equitable to allow an ex-partner to execute on the judgment from the corporation where they were both together in business. Waiver of protections. Note the Castro Bank on page 97. This may cause you to go running back to your form bank. The guarantee on a promissory note, and you may want to read the language on the screen, read in boldface, perhaps conspicuous language, the guarantor hereby consents to the attachment of garnishment of his, hers, its earnings. Obviously, from the pronouns, you know this was from the drafter's form bank. But returning back to the case, the 3rd DCA held that that language was unambiguous. As a result, the head of family exemption from garnishment was waived. Note for your future cases, for your future contracts, is this something that you want to put in your contract? From a public policy perspective, there is a substantial question, but the court did not really believe that the public policy, or did not use public policy to override the clear language of the contract. Moving forward into the next area, real property contracts, the graphic is of an early home inspection with a bear in the corner, and there appears to be a checklist that was being written on the wall by a new inhabitant in this cave. And it begins, make certain cave is empty before you move, and then it sort of ends. So, let's talk about writings. Mediation agreement terms for a real property contract. The Cohen versus Cohen case on page 101. And don't we love when siblings go at each other? And that's what the Cohen case provides. In a mediation agreement between the siblings, there was going to be a sale of jointly owned property. And the mediation agreement said that they would accept any contract not requiring seller financing. The court, the 3rd DCA, held that just because the two parties felt that the language meant different things, in other words, one of them didn't want to accept the other's offer, the court said that doesn't mean that the agreement is ambiguous. The parties were required to accept any contract that was provided as long as it meant the minimum price and as long as it didn't have financing requirements. The fact that it was offered by one of them did not mean that the other did not have to accept it. Leasing, on page 102, the Wave Blast versus Pompano case deals with what happens when a contract may not have an essential term. In this situation, the water sports company had a hotel beach concession, and the concession for these beach items would, quote, terminate on the demolition of the property, unquote. What happened to the hotel? Well, just like this week, the hurricane did come to shore and demolish it, so the owner, in essence, just renovated the hotel, but the parties recognized that it was not demolished. So now let's shift from the beach to the actual lease terms. The lease was for a term of years, it appeared, but the lease did not state how many years. It did not state an end date. And what the fourth recognized is that if a lease does not have an end date, that creates a tenancy at will, terminal in essence at any time. And in this situation, the term demolition of property was an uncertain term. Parole evidence was allowed to ascertain the intent of the parties. And the president admitted that the lease was to end when the hotel was to be torn down, which was an indefinite term. Moving forward on page 102 is the Corey versus Newfer case, dealing with that boogeyman of an agreement for deed. So, when you have an agreement for deed, that should put the hair on the back of your neck up. Always seems to be a problem with them. So, the holder of the agreement for deed foreclosed on that agreement. As a result, after the sale, there were surplus proceeds available. Chapter 45 provides that the owner of record is entitled to surplus proceeds after subordinate lien holders are paid. Again, the owner of record. The second analyzed what estate, if you would, did the heirs have for this property. The court noted they're not owners of the property, they're not assignees of the owner, they're not subordinate lien holders. This goes back to, as the court noted, an agreement for deed places ownership of the property in the seller. The buyer does not obtain ownership. Therefore, though it may appear unequitable, the holder of the agreement for deed gets the surplus proceeds, not the owner or the owner's heirs who actually paid in and created the equity. Right of first refusal was dealt with also on page 103 in the Acquisition Trust versus Lauren Pinebrook case. This situation, Publix had a right of first refusal on property, shopping center property. Publix exercise of the right of first refusal was for the same price as the third party was going to be paying for the property, but the exercise of the right had different due diligence terms and different terms on closing. In essence, as the second recognized, Publix did not give a point-by-point recitation of material terms. So the first item that the second came in was that simply notifying the seller that the holder of the right is going to be exercising the right is sufficient to trigger it. Next, once the right of first refusal has been triggered, at that point, the seller and the holder of the right can negotiate the terms that they want. They are not bound to the contract terms for the third-party purchaser. And that sort of makes sense because if the owner of the property is willing to change the terms, the owner is getting what they want. Unfortunately, it does leave the contract purchaser out to dry, you may say. Risk of loss. The Rivas versus Singh case, also on page 103, deals with what happens when you sit on your hands. In this situation, the owner knew that there was a wild deed out there, and did nothing for 2 years, and after the sale to what apparently was a bona fide purchaser for value. And the court held that in this situation, there were 2 potential parties that they had to rule for. The BFP, the bona fide purchaser for value, who didn't know about the problem, or the original owner who knew about that deed and didn't do anything about it. And what the court said was they are going to protect the person who is innocent. The least innocent, the one who could have prevented the misdeed by acting further, that's the one, as the court said, should suffer. So by passively watching, even with the recording requirements of the Recording Act, the owner may not be protected. Corporate procedure issues. Defamation. If you say it, you got to live with it. On page 105 is the Hulak versus Gibraltar case. The chief operating officer made statements to corporate executives and managerial employees. And the court held that even though some non-employees were board members present, the fact that it's made to the board of directors gives a protection, a privilege, and that does not constitute publication to a third party. Moving forward into covenant enforcement, as someone is being wheeled out on a dolly, apparently with their feet in cement and tied up, the statement is, let's just say the HOA doesn't think giving a second chance or a second notice should be necessary. By the way, we try to give a second notice before the death penalty is issued. But let's first start with covenants. Alternate dispute resolution covenants, the Hayslip case, which is reported on page 110 out of the second DCA. Some of you may recall the great hubbub when it first came out. U.S. Home, in its builder's deed, provided that all conditions and covenants in the deed run with the land, and also provided that this was a matter of interstate commerce, and further, the deed, not just the purchase agreement, but the recorded deed, that any dispute would be subject to arbitration, and also had the buyer sign the deed. So there was a sale of the property from the original consumer purchaser to a resale purchaser. So we are now dealing with a remote purchaser from the original purchaser and the developer. And there were alleged stucco and construction disputes. The owner filed suit to enforce. U.S. Home demanded that the matter proceed to arbitration pursuant to the deed ADR requirements. The court held that occupation and enjoyment of the home required then the parties proceed with their procedure to remedy building defects. The court also has certified this case as a case of great public importance, and I would imagine that the Florida Supreme Court would be looking at what point is a statement in a deed, particularly for a remote purchaser, actually a covenant running with the land as opposed to just a personal covenant and not binding on a remote purchaser. Interpreting covenants is the Beach Towing versus Sunset case, page 112 out of the third DCA. In this situation, the covenant required that the property will not be used as a parking lot, storage yard, facility, or garage or tow truck company. The court focused on the last language, or for a garage or a tow truck company. And the court held that nouns or verbs in a series, when there is a preposition or a postpositive modifier at the end, that will apply to everything beforehand. And they use the Latin term "associus socialis," which means it is known by its associates. So words that are grouped together in a list should all be given related meanings. So in this situation, they held that a tow truck company or garage meant that it would be a company for garage purposes, but would not prohibit a garage from being built. Private cause of action from zoning. The Chapman case on page 113 may be a game changer. The court held that a private citizen has standing to enforce a zoning ordinance when that owner proves special damages. And in this case, the owner was adjacent to the land at which there was an alleged zoning violation. And by mere proximity, there may be special damages that then allows that property owner to bring suit to enjoin that violation, or alternatively, perhaps for damages. Termination. Dania Beese versus Forcier, page 115. This is condominium termination, not an Arthur Schwarzenegger termination. The declaration of condominium requires that all owners, lien holders, mortgage holders must join in termination of the condominium. After the condominium was declared, the legislature amended the termination statute, section 718.117. That provided a lower percentage for approval for termination. The court held that unless the declaration of condominium has Kaufman language, that's language that says that in essence that changes to the Condominium Act are incorporated into the declaration of condominium, without that language, the court would not require that the condominium association utilize the current law, but was required to utilize the original provisions in the declaration of condominium. Note also reference to the Tropicana versus Tropical case out of the 3rd DCA. That was a 2016 case dealing with a similar issue. Reasonableness. This is reasonableness concerning an alteration in a covenant-controlled community. This was a homeowner association, but also presumably would apply to a condominium association. Is the Royal Harbor Yacht versus Marsima case on page 115. The association denied the application to install a boat lift because of its, quote, disharmonious appearance, or at least anticipated, and that it would be anticipated to obstruct view. Because reasonableness under the business judgment rule is an issue of fact, summary judgment could not be granted. Pre-suit arbitration as a requirement was dealt with in the Seawelt case on page 116 out of the 3rd DCA. A unit owner sued to declare a leasing amendment, an amendment that limited leasing, void. Sometime later, the association counterclaimed to enforce that provision. After the association filed its counterclaim, the unit owner then moved to dismiss the counterclaim on the basis that the association did not undertake mandatory pre-suit mediation as required by Chapter 718.1255. What the court held was that by filing suit in the first place in court and then waiting 3 years until the association counterclaim, the unit owner waived the right to contest the mandatory pre-suit arbitration requirements in the Condominium Act. And my apologies if I referred to the Homeowner Association Act a few moments ago. Furthermore, the association's filing of the counterclaim does not create a new threshold for requiring pre-suit arbitration. Alterations in the condominium context were the case in the Bailey versus Shelburne case. This case is not in your outline. It's a brand new case, July 15th, 2020. It's out of the 3rd DCA, Bailey, B-A-I-L-E-Y versus Shelburne. This case is important because it deals with ratification. The Condominium Act is, as the 3rd DCA, clear as it addresses material alterations, substantial additions to common elements, allowing only for 3 exceptions to an absolute prohibition on those in the condominium context. One is if it's provided in this section, 718.113, if it's provided for in the declaration, or if 75% of the owners vote for it. In this situation, the section itself, subsection 1, requires that associations maintain common elements. So in this situation, there was a requirement that the association undertake repairs. So as repairs that may also be alterations, no vote is required for those options. Said in other words, if work falls into two buckets, an alteration bucket and a repair bucket, the requirements for repairs will prevail. You don't have to get a vote as required for alterations. The association, though, got the 75% vote for items that were not repaired, but obtained the vote after the work was done. And the third DCA held that it would be absurd to allow a vote after the fact to ratify the work. You have to have the vote before the work's undertaken. Question: if the work's been done, how do you deal with the situation if you can't ratify it? And further, if the contractor would lien to be paid, doesn't the association have to pay the contractor and the assessment still needs to be paid? I don't know if the third has thought out all the potential implications of this. Eminent domain cases, note the Manatee versus Mandarin case, page 117 out of the second DCA. This is important dealing with the statute of limitations for challenging an ordinance. The timeline's on your screen. The ordinance was adopted in 1990. Suit was not filed until 2015. If the statute of limitation began on when the variance was denied, potentially would have been within the statute of limitations. But what the court held is when there's a facial, not an applied, but a facial objection to an ordinance that is unconstitutional, that challenge must be brought within the statute of limitations of original adoption. Ethics decisions, page 120. You know, if a case begins with the Florida bar versus, someone's in big trouble. So in this situation, dealt with trust accounts. The bar complaint alleged commingling and misusing of client trust funds. The court specifically noted that the attorney showed no remorse, undertook nothing to redeem the situation. And the court held, this is the Florida Supreme Court, that when a lawyer intentionally misappropriates client trust funds, the appropriate sanction is disbarment. No ifs, ands, or buts. So, no matter how hard up you are, you stay far away from your trust funds. Insurance issues, residency requirements, Arguelles versus Citizens on page 121 out of the third DCA. Very important for your clients that may be absentee owners, especially if they're leasing. The insurance policy, the casualty policy, provided that the residence premises was insured, and that was defined as where you reside. The owner moved to New York and rented out the premises. It was no longer a residence under any definition. The third DCA, again, clear and ambiguous reading of the contract. Coverage was only there if the owner lived in the unit. And they looked at the dictionary definition of reside, to live in a place permanently or for an extended place of time, and that the owner was not doing. Big problem on this case for the owner was the owner didn't know about the lapse of coverage until after the loss. Subrogation in the condominium context was the subject on page 122 in the Universal versus Loftus case. This is one of those situations when water comes from the upstairs owner to the downstairs owner. Can the downstairs owner, or perhaps more importantly for this case, may the downstairs owner's insurance company exercise a right of subrogation against the upstairs owner? And the court held that while the Condominium Act 718.11111J requires that an owner pay, that does not create a private cause of action. The right of subrogation provided in the statute only was there to not disturb an existing insurer's right of subrogation, but there is no private cause of action. Named perils, though this arose out of a condominium, it may apply to any property owner's windstorm, rain, or other casualty coverage. In the Citizens Kings Creek case on page 125, the third DCA noted that the association filed suit 3 years after the loss. Maybe they were a little bit, shall we say, disenchanted with the claim. The court also noted that there were 3 roofs that were installed, one on top of each other. But the key here is that the policy was a named perils. It only insured for wind and rain. And under a named perils policy, the burden of proving the cause of the loss is on the insured property owner. It is not an exclusion. It is not a burden for the insurance company. Statutory interpretation issues. I have one case in this area, page 127. Please note the state of Florida versus Poole case. This case is a game changer all across the board. Though obviously because it's state of Florida, this is a criminal case. And you're going to say, what does that have to do with real property law? Because of course none of your clients are criminals, but very seriously, the court rewrote the rules on stare decisis, or what is the role of precedent in the law. And what the court said is that because the court is bound by what it called a higher legal authority, that if the court thinks that a precedent is wrong, it should not be followed. Up to this time, this court, as well as the U.S. Supreme Court and most Supreme Courts across the land, held what was used to be called a precedential view. And that is, even if the court today may think it is wrong, unless there are substantial reasons to change it, the need for certainty in the law, as well as having public confidence that the law doesn't change every time you change who's ever on the Supreme Court, does not mean that you just flip-flop, if you would, on cases and change precedent. We will see what this does in the future for challenges. It may also undermine the effectiveness of 57-105(1) and 2 in challenging on a frivolous basis. Taxation issues. Homestead seems to be the key in the Baldwin versus Hernandez case on page 129. If you don't live in the house, you are not entitled to a homestead. Also, to Homestead, the Fitz versus First case on page 129, through something not of the Florida owner's mistake. The Florida owner also had listed a homestead in Ohio and therefore could not claim the Florida homestead and lost it retroactively. The Gannon versus Airbnb case on page 130, Airbnb is not required to collect and pay the best bed tax because it is a mere conduit, but it is not the holder of an interest that is a leasehold. Title issues. Note the Dania versus Elias case on page 134 for prescriptive easements and the 4-point test that is there. Even though parties may have used a common driveway for 60 years, if they did it friendly, it is not adverse, it is not prescriptive. Page 135, the City of Miami case deals with certified copies, an electronically filed code lien, not one that's physically stamped certified copy, is entitled to certified copy status, and as a result, that now becomes a lien. Anderson versus Latowski, page 136, another homestead case. This was a case, whether a homestead is protected against creditor claims after death. The homestead was rented, but only 3 of the 4 bedrooms. The decedent lived in the 4th bedroom. The court held you cannot devise a homestead. The fact that 3/4 of the bedrooms were leased does not remove the homestead protection. Tort cases, the Walters case on page 144 out of the 3rd DCA, there was a hole in the condominium association's common element doc. Condominium association may be jointly and severally liable with the contractor that did properly repair or fix that hole, but importantly, the association has a non-delegatable statutory duty to maintain and repair. Timing, the Frederick case on page 147, if you're dealing with commercial properties, 41 seconds after the spill, someone walked into the place and fell. The manager saw it, and in between that time went to get cleaning supplies. What the court held was that while there was not a breach of the duty to maintain because the manager rushed off to get the supplies, there was an issue as to whether there was a proper warning in that 41-second time period. The last case is literally the spoofing schmuck case. And this was a cyber stalking case. And what the court held was that if someone posts on their own media page, that is not being directed at you or a specific person. And the court also held that by looking at those items, a objectively reasonable person would not have suffered severe emotional distress or substantial emotional distress as a result of the tweets, and therefore no cyber stalking claim would be allowed. As we finish, as the bells go off, a reminder. Some of you have had the opportunity to meet my daughter Sarah. She understands that being from a family of attorneys, she is a person in many ways of privilege. When she graduated, as shown here from law school, she had many mentors. Many of them are you. What we need, individuals like you specifically, to go out and mentor someone who does not look like me, like her, like you, someone who grew up in a different place, went to a different school, may speak with a different accent. Because if we do not mentor others who do not have the opportunity, then the law will not reflect society and will not be able to protect society the way the law has in many times. As we move forward, we understand the importance of the law. Recently, we've just observed the passing of Congressman John Lewis. John Lewis wrote, recognizing what the future would bring, an opinion that was published on the date of his funeral. He recognized the words of Martin Luther King when he remembered that King said, "We are all complicit when we tolerate injustice." King said that it's not enough to say it will get better by and by. He said each of us has a moral obligation to stand up, and speak out. When you see something that is not right, you must say something. You must do something. Democracy, as Lewis wrote, is not a state, it is an act. And each generation must do its part to help build what we called beloved community, a nation, and a world society at peace with itself. And in Lewis's final words to the nation, a man that was revered by individuals on both sides of the aisle for many decades, who literally put his life on the line for the values of the law, an effort that thankfully many of us will never have to be called on to do. He urged us to answer the highest calling of your heart and stand up for what you truly believe. He wrote, "In my life, I have done all I can to demonstrate that the way of peace, the way of love and nonviolence is the more excellent way. Now it is your turn to let freedom ring." The law has allowed many of us to live in freedom because places where our forefathers, our ancestors came from would not allow it. It allowed us to prosper in ways that others don't. It is up to us to stand up and be counted, and I urge you to do so. Thank you.